Hello, good day sir. We are from Group 12. We are going to present about separate legal entity of a company based on Solomon vs. Solomon, the Company Ltd 1896 Act 22. Group 12 consists of 5 persons, which are Didi, Nazerah Sarbini, Nurwahida, and also me, Pravin. Stay tuned with us to know more about separate legal entity of a company based on Solomon vs. Solomon and Company Ltd 1897 Act 22. Thank you.
Greetings everyone, my name is Nurwahida binti Ariffin, matrix number 71253, and today I am going to discuss about a very interesting case law of separate legal entity, which is Solomon vs. Solomon and Company Limited. We know that the company has a legal entity and it has its own legal existence independent of its member and directors. It was in the year of 1897 where Mr. Aaron Solomon was a sole proprietor of a shoe business. The business was small but yet profitable. He decided to incorporate his business as a limited liability company. He gave 1 shares each to his wife and his 5 children. He himself took 20,001 of 20,007 shares. In consideration, the debentures were issued to Solomon. But suddenly, the business was plundered and Solomon was unable to salvage the company and the company was put into a liquidation. That's all for my part. Thank you.
Hi, I'm Serena. Now I talk about the issue of Solomon case. The issue is Mr. Solomon should be made responsible for company's debts and shouldn't be paid, forgetting he only had limited liability and that the company was a separate legal entity. Solomon incorporated his bookmaking business, Solomon Limited Company, with himself and his family as members. Solomon was compensated through shares and debentures secured by the company's asset. Solomon's right of recovery, which is secured through floating charge against the debentors, stood prior to the claims of unsecured creditors, who would have recovered nothing from the liquidation proceeds. On behalf of the company's unsecured creditors, the company liquidator said that the company's business was actually Solomon's own business and that the company was only set up to avoid debt in case Solomon's business failed. He asked Solomon to pay off the company's debt and denied Solomon's claims to the company's secured debts. That's all from me, thank you.
Now, we know that from a legal point of view, a Solomon company, once duly registered, becomes a legal person distinct from Solomon with its own independent right and obligation, fully liable with its separate property, and the shareholders are not independently liable to creditors, but only limited to the extent of their capital contribution. At the time, however, there was no such provision. Thus, when the case went to the High Court, the Court of First Instance held that Solomon's company was nothing more than Solomon's avatar and agent, and that the company money was Solomon's money, and that Solomon had no reason to pay itself back, thus ruling that Solomon should pay off the debt of its unsecured creditors. The appeal court largely upheld the judgment under the Company Act 1892 and 1862, stating that the company was no more than a virtual identity and that Solomon should pay the debts incurred by the company.
So, from the whole point of this case is that this case established and explained that a person may function in dual capacity. So that means you can be director, a shareholder, and employee at the same time, and that an agent of the company could negotiate a contract of services as between the company and himself, meaning that him being a shelter director cannot stop him from actually being an employee and having a spread contract with the company itself as an employee. Under another amendment, the minimum number of directors needed to be designated in a proprietary company was cut from 2 to 1. Moreover, the Corporation Act states that any sort of company, not just a proprietary company, may be established with only 1 member and may continue to exist with only 1 member, section 114. It will appear then that a overall balance is positive and that the discussion of the House of Lords in Solomon v. Solomon and Company Limited was a good discussion. So that's all from our group. Thank you.